Welcome everyone to Gearhart Law's Entrepreneurial Strategy Series event entitled Global Business Strategies and Intellectual Property. My name is Ashley Sperbeck and I'm an IP attorney here at Gearhart Law. To obtain protection on a product or invention in a foreign market, a business may have to file for IP protection overseas. This can be difficult as the laws vary in each individual country. The ESS event for today will feature several speakers from Canada and the European Union who will address questions such as, how difficult is it for an entrepreneur to expand their business overseas? And what do inventors need to know? And how do they protect their products from competitors in foreign markets? This presentation today is designed to be interactive. So if you have a question, please feel free to leave it in the chat or raise your hand and one of our speakers will call on you. I would like to now turn it over to our esteemed speakers to introduce themselves one at a time. Serge, do you want to begin?
Thank you, Ashley. So my name is Serge Lapointe. I'm a partner with Fasken in Montreal. So my background is a PhD in biochemistry. I've been practicing IP law both within law firms and also within biotech companies for the last 25 years. And I'm glad to be here today to speak about Canadian patent law.
Hello, my name is Vincenzo Melilli. I'm based in Milano. I'm the head of the design law department in my firm. I've been with my firm for 15 years, so it's quite a few years of experience on this. I'm a professor into university at Politecnico of Milano, a Catholic University of Milano. I'm very happy to be here, and thank you, David, thank you, Ashley, thank you, Richard, for inviting me and to share this information.
Hello, good morning. My name is Ugo Rossi. I work for Bungnion as well as Vincenzo. I am a European patent attorney, and I have more or less 20 years of experience in this field. And before, I was working in a management consulting firm. And my subject matter is software and electrical patents, and this technical field in particular. Thank you for inviting us, and thank you for joining us.
Hi, everyone. My name is Jane Wu. I am an intellectual property lawyer and a trademark agent at Fasken. I'm based in the Montreal office, and I'm happy to be here. Thank you for having me.
Great, thank you everyone. So today we'll begin our discussion regarding trademarks. One of the major questions that I typically get is, how does the trademark filing and examination process, how does it work overseas? I was hoping Jane or Vincenzo could take this question for us.
Yes, you know, to be honest, I have also the time, just a sample of a timeline. So just to show you how the process works, and just give me a second to share the timeline with you. Here we go. This is just a typical timeline of the European Union trademark. So the European Union trademark is, as all trademarks starts with filing. So we have a filing on a certain date, and then we have an examination. Unlike US and many other jurisdictions in the EU, you don't have the examination on prior rights. So what the examination does is just looking for distinctiveness, genericness, and all like the basic general the impediments on absolute grounds and not on relative grounds. Then we have the opposition, the publication for opposition, and after 3 months, if no opposition is filed, we have the registration obtained. This slide, actually, this picture was supposed to be used to show the use requirement in the EU, which is completely different than many other jurisdictions. So from the registration date, we have 5 full years where the trademark is enforceable. So I can file oppositions, I can send cease and desist letters without not even using it once. So this is also important for US companies because, you know, sometimes you have the use it or lose it system, and having a European trademark allows you to have 45 classes covered without using it for 5 full years. And that's it. Then we have 10 years renewals based on the date of application. So each 10 years starts from the date of application and not from the date of registration or publication. Hope this is clear.
Can I ask a question?
Of course.
Hi, Vincenzo. It's good to see you again. So when you register a trademark in the European Union, you said, if I understood you correctly, it's automatically registered in all classes, so you don't have to select particular classes, or you?
No, this is just a feature. So I was just, you know, going by, you know, I was extending the hypothesis that you could cover all 45 classes without using the mark for 5 years. So you will get a monopoly over a word for 5 years without use, not even intention to use the mark. So you pay the fees per class. So this is just very, you know, as anybody knows in other jurisdictions. But unlike other jurisdictions where you need an intention to use the mark or you need evidence of use, so in this case, you have 5 years from registration of full enforceability. So oppositions, so cease and desist letter, even without using the mark. So this is just very.
And then after 5 years, do you have to narrow the registration to the classes where you're actually using it, or do you?
This is not even the case, because unless the trademark is challenged, you can keep all 45 classes forever. So if somebody, you know, makes an in-use investigation and knows that you are not using it and wants to challenge your classes, one of your classes, you know, they file a cancellation action. But unless a cancellation action is filed, so you keep all classes till the end. So this is another very interesting tool, because you never show use unless it is required by somebody else, by competitors usually.
Thank you.
Thank you. Thank you, Richard.
Thank you. That was very interesting. Jane, can you give us your impression here as well?
Yeah, sure. If you may, I will take a step back on the difference on the registered and registered marks, or why it's worthwhile filing for application. So in Canada, when you have a registered mark, there's a legal presumption that you're the owner. If you do not have a registered mark, you're just using it informally, like in the market, you still have some sort of a protection, but it's more limited in the sense that you have to prove that you own it. So it means you need to prove your goodwill, the reputation that you have, and the territorial area. So the difference, you have a difference in terms of territory. In the case of a registered mark, the protection is national, Canada-wide. But if it's unregistered, let's say you only have activities in Vancouver, but you don't have any activities in Toronto or Montreal, then what you don't have a basis to sue a third party using the mark in an area that you do not have any goodwill or reputation. So that's like a very important difference to keep in mind, and the benefit of filing an application. And the second point is the legal recourses. There are legal recourses that are only available for the owner of a registered mark. So if you do not have a registration, then it's not available to you. Can you still sue a third party? Yes. Is it more complicated in terms of evidence? Because the burden will be shifted on you to prove your right first. Who are you? Are you the owner? Okay, to what extent are you the owner? For what? Instead of you're coming with a certificate of registration, and that's the presumption that you're the owner. So these two factors are important for the business owners to consider. And in terms of the process of the trademark prosecution, there are two critical moments. So the first critical moment is examination, and I'm going to talk about the elephant in the room. Some of you may know how long it is in Canada to get to examination. So, but there are ways, there's a mechanism that could accelerate the process. But now I'm just going to give an overview. So the first is examination, and unlike in the European Union, in Canada, the examiner will look at the substantive grounds and relative grounds of the criteria. So if there's prior rights, you will get an objection for a confusing mark. Same for the specificity of the description of goods and services. I know in some jurisdiction you can just cover software and will be good enough, it's specific enough. But in Canada, it's not the case. You need to say, okay, it's a software. In which field? What are the functions? Oh, this is a specificity. I believe it's a bit similar as in the US, but for Europe, usually you really need to get much more specific. So let's say there's no objection, and are you able to overcome the objection? The second critical moment is the opposition. It's 2 months in Canada. And usually we say, okay, when there's no opposition by a third party or opposition was dropped, then you get the registration. So what does it mean? That means that at the filing time, unlikely in the United States, in Canada, we don't need any filing basis. There's no use requirement in order to obtain the certificate. However, if you do not use your mark within 3 years of the registration, a third party can initiate the administrative proceeding, which is the expungement proceeding, and you have the burden to prove that 3 years within that notice, you have evidence of use in Canada. Same principle, you don't use it, you lose the registration. So that's the overview.
Great, thank you, Jane. That was really helpful. So my next general question is, what are the common difficulties or pitfalls you typically see when clients are applying for a trademark right in either Canada or in the EU? And what sort of suggestions would you make to these clients to avoid those issues in the future?
Actually, in Europe, one of the first difficulty that trademark holders have is on the naming, so finding available words. So I know that there is a study from New York University that's saying, are we running out of trademarks? So apparently we are running out of words available as trademarks. So apparently the word ACE is not available in any classes ever. In Europe, we are facing this, but we have a double system. So we have a system that works nationally, and the European Union is not a nation. Is a whole, is a system, is a jurisdiction, but is composed of little nations, Italy, France, Spain. So an Italian trademark, a German trademark are able to strike down a European trademark as a whole. So this is the double standard that makes us face a much worse problem, because we don't have just one jurisdiction like federal trademarks or Canadian trademark. We have national trademarks, Germany, Spain, Croatia, and then we have Europe as a whole. This means that if the prior trademarks is only nation-based, so let's say we have a prior trademark in Spain, but my trademark is meant to be used in Germany, they can coexist. So we recommend that when we do the searches, the prior mark searches and availability searches, if national trademarks come up, and then we are not able to say register in the EU as a whole, we ask, which national country are you interested in? And then we will turn into national registrations. So, that they can coexist, and, the clients are also serving their own purpose of using the mark. Is that clear, Ashley?
Yes, exactly. Thank you. Jane, do you have anything to add to this question?
Yes, so what I see is the misunderstanding of how the examination criteria are conducted in Canada, how broad interpretation for the lack of distinctiveness objection is broad in Canada. So a trademark, its function is to point to a source. It's a source identifier. You're using a mark to point to your goods and services. And if a mark is not able to point towards your goods and services from the others, to distinguish yourself from the others, then it cannot function as a mark. And there's a criteria in Canada that if you don't have that function, the examiner will object to your application. And it's very common, this objection, that there are ways around who have been successful to overcome that objection. But when you're filing in Canada, please bear in mind that, especially when you have somewhat descriptive or even suggestive mark, you might get an objection, and you should budget more fees in order to get your registration, because it probably will not be a smooth prosecution. You will have to invest a bit more. So that's the number one. Number two, when we talk about third-party rights, well, it's easy when, I take Fasken, for example, you have Fasken and something similar to Fasken. But when it's a word in English, you also have to think about the meaning in French when you're conducting the availability search, because the legal test is bilingual. It's in French and in English. It's something that not a lot of business owners are aware of, but you also need to consider the French part of Canada. And so sometimes, even if the English words and the French words do not sound the same, do not look the same, but the meaning is similar, the examiner will object. So I would say like these two particularities to the Canadian examination process.
That was really interesting. Thank you for that. Do you have an example of a word that, like you were saying, there could be an issue in both English and French? Maybe one version would be registerable in Canada, but the other version wouldn't, just for the audience?
Right, so I take an example that's very different. Factory in French is usine. Absolutely nothing to do with each other, but it's the direct translation. So it's the same meaning.
Okay, great, thank you. I'm going to move the discussion on a
Here
little bit.
now, Ashley, if I may add something to Jane's speech, we have also 26 languages to look into. So this brings us that the distinctiveness should be, looked into not just in English or in French, but also in Greek, in Italian, in French, in Croatian. So, and it's very, very common that some words sound like generic words in Danish, and then you get a refusal because in Danish it's descriptive. Thank you, Jane, for bringing this up.
Yeah, that's definitely something interesting that clients will have to consider overseas. I'm going to move the discussion on a little bit to the patent sense, just so our other speakers can get a chance to describe their realm as well. So one of the major questions I get is, how does the examination process for patents occur overseas? So maybe we can go over the process in both Canada and the EU.
May I start, or Serge starts in Canada?
It doesn't matter, whatever you guys prefer.
You want to start, Serge?
Okay, sure, I'll be glad to. So thank you. First of all, for Canada, I cannot stress out the importance enough of filing for a Canadian patent, because there's no other countries, two other countries in the world that have so much business together than Canada and the United States. Every day, billions of dollars in goods goes from one side of the border to the other side. And we've seen the implications of that in spring when the bridge was blocked between Windsor and Detroit, how that affected the US economy. So here, it's very important for US businesses to protect the Canadian the Canadian market by patenting in Canada, because it's not an exceptional case where the goods that are being sold in the US are being manufactured in Canada, and it's going to be much less expensive, with all due respect to my US colleague, to litigate in Canada if that's the case, or if the infringer is on both sides, then the Canada could be a test case for the more complex US litigation. So that's my first message regarding Canadian practice. So in terms of filing, I would say there's a lot of things that are common with the US filings and Canadian filings. One of the things which is very convenient for both countries is the fact that we have a grace period in Canada as well. So if you have disclosed your invention, well, it's not too late to file in Canada within a year. The only difference here, important difference here, is that in the US, you can file a US provisional, and that's going to be it. And if you use that provisional and go in Canada, if you have disclosed the invention, that's not going to work, because for Canada, for the grace period to apply, it has to be a complete application. So just claiming priority won't be enough. So there you could file a US provisional and have a regular application in Canada. Oh, I see, maybe we have a question.
Yep, please go ahead.
Are you talking to me?
Yes, go ahead. Please ask your question.
Yeah, okay. So first of all, my name is Moise Aladdin. Okay, and I'm from Sudan, and I'm a business manager. Okay, so I work for a researcher, a Sudanese researcher that has a grant in USA and another grant in Saudi Arabia, and also has an international patent, WIPO, for the cure of asthma. And as you might know, asthma has over 300 million cases worldwide. And now I really don't have contacts. I really don't have a lot of people overseas, especially in Europe or especially in America. So she said that she's trying to sell her patent for $280 million. Okay, so I'm trying to find, when I got your email, I was like, you can take questions like this. So if you were, yeah, if you were in my position, what would you do? I need a lawyer or someone that can contact me to big companies like maybe Pfizer, maybe companies that would take this drug and to maybe get into partnerships with the researcher and I, maybe like 50-50, and we would distribute on a worldwide range because asthma is very common. And maybe we would find a company that will take off the whole patent for 280 million, and she's even done clinical trials on 130 people, and she's proven a record time of 14 days to treat asthma completely.
Thank you, Moise.
And it's also
Moise, I'll send you my direct contact information and we can discuss this after, just so the additional speakers can present their topics, if that's okay.
okay. You're gonna send me your what?
I'll send you my email address so we can go through the other speakers' presentations and we can discuss this after the call, if that works for you.
Okay, you have my email, info@OLASupplement.
Yes. So I will send that to you after, but we want the other presenters to get a chance to speak, if that's okay.
Okay, that's good by me.
Yep.
So I'll speak to you after.
Wonderful.
Thank you.
Mhm.
Okay, I will talk briefly about the European patent system, which is a little bit complex, as before Vincent mentioned, since Europe is made of many nations. So we have this European Patent Convention where we have 38 contracting states. We don't have to mix up Europe, European Union, and the European contracting states for the European patent or European patent application. For example, after Brexit, UK is not in the European Union anymore. UK is in Europe, but UK is still a contracting state of the European patent because it's a contracting state. Also, Switzerland, which is not part of the European Union, is part of the European patent system. So we have 38 contracting states for the European Patent Convention. We have also some extension states. We have some North African countries, and we have also Cambodia being part of the European patent system. And there are some big differences maybe between the US patent system and the European patent system, or the Canadian patent system and European patent system. The first one is that we have one unified procedure like in Canada and the US, but in one of the three official European languages, which are French, English, or German. Then when the European patent gets granted, you have 4 months to decide in which national European countries, contracting states, you want to validate it. So you will have to decide if you want all of them or some of them. So once they are validated, they are national rights and they are national patents, and the European patent does not exist anymore. So it's like having a prosecution in the US and then you can validate in Wyoming, Ohio, and Florida, and is not validated in other US countries. So we have unified procedure, but after the European patent has been examined and has been granted, in a short period of time, you have to decide in which European contracting states you want to validate your European patent application. One big difference between Canada, US, and Europe is that in Europe, we don't have the grace period. So the big pitfall is that a US applicant or Canadian applicant who has 12 months, at least in the US, of grace period, they can disclose their invention, maybe by a speaking or on the internet or by a written publication. Then they can file their US or Canadian application, and then they can claim priority from it and come to Europe. The problem is that in Europe, since we don't have this grace period, the prior publication or disclosure of the invention in the 12 months period of the grace period will be novelty destroying for the European application. So the first tip is if the applicant, the US applicant or Canadian applicant, has in mind to come at some point in Europe, national by a single states, European states, or by the European patent system, the first thing is not to disclose the invention before filing the first application. Hello?
I hope so. I pressed your animal. Please don't transfer me until you're clear. Can you hear me?
Yes.
Okay. I pressed to speak with animal control before.
Ashley, you can mute her. Thanks.
Got it.
Sorry about that. You go.
Okay, and other thing we don't have in Europe is the provisional application. So there are no provisional applications at all in Europe, but you can claim priority from a US provisional application. A US filed provisional application, you can then claim the priority when you want to come to Europe. So these are the two big differences. Then there are some new developments that are coming, which are called the Unified Patent System, which will allow to the European countries that will be part of this new system to have a centralized European patent application and patent, and you will not need to translate and to file into national rights in the single contracting states. And we will have a unified court where you can apply for infringement or for defending your invention. I don't know if I've been clear and if there are questions about that.
I think that was very clear. Thank you. So one of the other common questions we get is, in the US, there's numerous types of patent applications one can apply for, whether it be on a new plant variety, a design, or a new and useful product, or something like that. Are all those available in Canada and the EU? And how does patentable subject matter differ in those countries?
I start. This is a good topic, a good question, actually, since in Europe, for the European patent system, we don't have a definition of what an invention is, but we have a negative assertion saying what is not patentable under European patent law. And unfortunately, Europe is stricter than the US, at least, I don't know, Canada, for what can be patentable. For example, business methods are not patentable in Europe. Methods of surgery on the human body are not patentable in Europe. So if you want to protect a catheter, surgery catheter, you can protect the device, the apparatus, but you cannot protect the method of insertion, of using this catheter to put inside the human body. So we have to be very careful. Usually, when US applicants are coming to Europe, you can find some kind of invention which are not patentable. For example, even the software per se is not patentable in Europe, but if we have a mixture of software, hardware, and we solve a technical problem, we can find a workaround to file or to protect the invention. Even discoveries or mathematic methods, games are not patentable in Europe. For example, I know Monopoly has a US patent very long time ago granted, and these kind of patents cannot be granted and cannot be filed in Europe. So they will be most commonly objected to when you file these kind of patents. And of course, there is some provisions for the plant varieties, and I think they are patentable, but it's a separate subject matter from the patent system in Europe. And that's more or less all. Also, okay, inventions contrary to the public order are not allowable in Europe. I think probably also in the US and Canada should be something similar to that.
Okay, thank you.
Actually, you were mentioning also the design patents, right?
Yes.
On the matter. But in contrast, just to add the piece of Europe. In contrast, in Europe, we have much broader possibilities for design patents, much broader. So we have subject matters which are not allowed in the US, which will be in Europe. I'll show you some example which are very self-explanatory. So we have pattern. So patterns in general are, in the US, as I understand, you need an article on manufacture. So this pattern should be applied to televisions, to lamps, to materials. In Europe, this is protected generally as a pattern. So it's much broader. We have also logos. So multiple logos applied to anything, just protected per se as logos. So we have characters. This is a nice character, but you don't need to apply the character to some specific field. What you need is to, you protect the character. Same for graphic user interface. They can be projected. So you don't need an article on manufacture showing the broken lines. That's what we get from the United States. So this is more flexible as a matter. And I think also with all the discussions, I don't know if somebody is involved with metaverse and all this kind of discussion, it's much more versatile because you use the coat, you use the bag, and no matter where it's used to or applied to, this is protected per se. So hopefully this is helpful on the, on broadening the scope for protection for design patents in Europe.
Yes, that was definitely helpful. Thank you. Another common question we get is, how is counterfeiting treated overseas? So if I have a product, I have a patent in the United States, and I make my product in Canada or in the EU, and someone counterfeits it, what are the remedies available to me as an inventor? I guess in both situations, the first situation in which I do have patent protection in the underlying country, so I do have it in Canada or I do have it in the EU, or in the situation where I don't have any patent protection overseas in Canada or in the EU.
I don't know if Serge wants to take.
Well, maybe I can say a few words. I'm not a litigator, but of course, if you want to have, if to need rights in a country, you need to have some kind of protections in that country, of course. So if you want to, if you think that your device or product is being infringed, so you need, of course, to have either have a patent in Canada, for instance, a design or trademark protection or something to enforce your rights. Depending of the court as well, you might have access to injunctions. Like in Quebec, we can have that. So depending on the reasons and kind of so there are some available options, of course.
Okay, like Serge, I am also not a litigator, but I would like just to stress out that the EU patent is only a unified procedure for the examination, from filing to examination and to grant. But after grant, it becomes a bundle of national rights, which are validated in the European contracting states selected by the applicant. And then they have their own fate, and they can be prosecuted or only by national basis, and there is no centralized basis. The only thing we can do, we have 9 months from the granting of the European patent, where it's possible to file a centralized opposition procedure in Munich and file it at the European Patent Office. And this can be done by the European patent attorneys. So if you have a competitor in Europe or which has a patent in Europe which has been granted, recently granted, what can be done is not very expensive, is to go over it during the 9 months period of opposition, of patent opposition. After that time has lapsed, the European patent does not exist anymore, and we have just a bundle of national rights. So you have to go in each jurisdiction, hiring local lawyers and filing in the local tribunals. I have just, you want to see, so do you see my slide?
Yes.
Okay, so we have the filing of the European application, more or less 3 to 5 years to grant. This is only one procedure in one language. So for US and Canadians can be English or French. Then once the European patent is granted, you decide, the applicant decides in which European countries to enter. Once you enter the single countries, the European patent does not exist anymore. So if you have an infringer in Great Britain and one in Italy, you will have to hire local lawyers and to file in the 2 local tribunals for the infringement. So this is quite different, I think, to the US and to the Canada. The only way to have a centralized infringement procedure is to file this opposition in the 9 months from the granting of the European patent. And this is centralized. So if the patent gets limited or revoked, it will be ab initio and it will be in all the contracting states. And as Vincenzo said, for the trademarks, at filing the European patent application, all the 38 contracting states are activated. And at the end of the procedure, you select which ones you want to enter, because this has costs of translation and of filing locally. So these are all the 38, which at the end are 44 countries. Also Norway, which is not European Union, it's in the European patent system.
Great, thank you. And so for just the next general question, what are some helpful tips you could give to an inventor who wants to protect their invention via a patent in either Canada or the EU? And maybe what are some common pitfalls that they might encounter in their process?
Maybe I'll start. So of course, even though if there's a grace period, so the first thing would be not to disclose their invention, to talk to their US counsel and see how we can properly draft the patent application and cover everything. Also, based on the fact that there are national laws which change a bit. So depending on what you can protect, so it's never a bad idea if you already know where you want to commercialize to have to maybe craft the patent in a certain way that you already cover some aspect. Because like for Canada, for instance, you cannot, a bit like Europe, you cannot protect the method of medical treatment, but there's a way to protect the use. So if you have some wordings around that, the way you're going to use the device, then you can have some valuable claims on the use of the device. So that's one example. Other than that, in Canada, for US companies, it's quite easy, I would say, to get the patent, because typically in Canada, there's no obligation to request examination until 4 years. So you typically entrepreneurs obtain their US patent, sometimes they even get their Canadian patents, and then we align prosecution accordingly. So it's really easy because they have already addressed all the prior art, and it's quite easy to get the patents, and we can make some adjustment if it's a method of treatment to cover use and things like that.
Okay, for Europe, more or less are similar to Canada's suggestions. The first one, as we already said, is do not disclose your invention during the grace period, because this will invalidate your European patent application. The second one is that in Europe, there are some differences with the US examiners, since, for example, for amending the claims during examination, they are much more stricter than in the US. The US patent law, the EU patent law stems from German patent law. So they are very, very strict when you have to amend the claims. So you have to provide support, literal support from the description when you amend the claims. So it is important to have a very detailed description and specifications in order to later on have tools, technical tools to amend the claims during an examination. Another difference we have in Europe, we have four claim categories, and usually one European application can only have one claim category for each claim. In the US, I think you can have as many as you want, and after 3, maybe you have just to pay one claim fee. But in Europe, you can only have one claim per claim category. And it is also possible in Europe, it's easy to get patent applications granted having the device claim and the method claim. Of course, there has to be unity of invention. So all the technical features in the device have been translated into process steps in the method claim. I know in the US, probably you get an election office action and you have to split maybe in more than one application. Another maybe difference we can have between Europe and the US is that the right to the patent in the US, I think, is for the inventor. In Europe, we have the inventor and the applicant. So it is very important if the US application has been assigned by the inventor to the applicant or to a company, to assign also the right to claim priority before filing the European application, claiming back the priority of the US application. It seems easy, but sometimes it happens to find kind of problems if the US patent has not been properly assigned before claiming the European and the priority.
Okay, great, thank you. And just another question that we typically get, how long is the examination process for either a trademark or a patent application from when it's filed? And what are the typical costs that an inventor or someone just filing a trademark could anticipate in the future for either a trademark or a patent?
On the trademark side, this European Union as a whole, the European trademark is very beneficial because you get 26 countries, 26 jurisdictions, and you pay just more or less €1,000, which is very convenient. Before you had to have national jurisdictions, so it would have been 26 times as the European Union. In terms of strategy, of course, European Union as a whole is more convenient and beneficial. But if we have some strategic issues, as I said, you have a prior mark in Spain or a prior mark in Croatia, so you are forced to go for the national registration, which you select basis on the prior rights on the territory. In terms of time, it's very straightforward. So the examination is 2-3 weeks, more or less. Then you get the publication, then 3 months. So what I usually do with especially startups which want to benefit from the priority, I used to say that in 5 months, more or less, you understand what is the situation. So 5 months, 4 or 5 months is the minimum standards, of course.
For Canada, the situation is much more different, I would say. So the average length currently for just the to get to the examination. So that's the first critical moment I talked about earlier. It would take about 18 to 30 months. That's just to get to the first stage, to get the examiner looking at your application. But on the good sides is that there are other mechanisms and advantages at the filing stage. So first of all, in terms of fees, unlike in the US and Canada, starting for the second class, there's like a discount. It's not the same amount of fees per class. The first is higher, but the second, third ones are lower. So that's the first thing. And second of all, there's what we call the Goods and Services Manual. So if Canada is an important market for you and you want your application to be processed more like quicker than the average length I just said, then we can use and take advantage of the manual. They are a list of pre-approved items. It is not exhaustive, but you can still find a fairly amount of items that could fit your business. Of course, if you are in the technology software area, the manual might not be the most updated, but I would say that it is regularly updated. So we can work with that. And the advantage of picking from the manual those pre-approved items rather than having your own customized description of your goods and services, the difference is 1 to 1.5 years faster. So and yes, the Canadian Trademarks Office are improving. So this delay is hopefully going to be shorter, but it doesn't give a challenge to the business owners, which means that even if everything goes well, you will not get your certificate within the same year of the filing. You need to think at the filing stage what your business will look like in 2-3 years. What are the goods and services you're not offering right now, but you would want to have them covered in 2-3 years? And that's fine that it's not used at the filing date. Like I said earlier, there's no filing basis in Canada as long as you have good faith, you have the intention to actually use your mark in association with those goods and services. You can add them. So that's a tip that I usually give the business owners who want to file in Canada, considering the long delay in the examination. And this, lastly, there are requests for expedited examination in a specific situation. So it's a closed list. If you fit in it, you might want to look at it further and see if you want to take advantage of the request. So if there's a court action underway in Canada against you, and you just have a pending application, you want to get a registration in order to have other legal recourses available to you as a registered trademark owner. If you are combating counterfeit products at the Canadian border, or if you believe you will be severely disadvantaged on online marketplace. So that's broad. There's no jurisprudence at this point to guide us to what extent is this disadvantage on the market online place. But it's worth having a look at this criteria and this basis. And lastly, if you have a priority deadline with other offices and you really need to have to accelerate your Canadian application. So that's something you can discuss with your Canadian agent, and we can look at if you fit in one of those situations. If you do, then the acceleration from our experience, rather than waiting from 18 to 30 months, it can be 1 month or 2. So that's some little tips and tricks to accelerate the examination in Canada.
Thank you, Jane. To continue in Canada for patents, I would say that examination process can be very short, it can be quite long depending on the client strategy. As I said, when you file a patent application, examination is not automatic, so you have to pay a fee and request examination. You can postpone that for up to 4 years after the filing. When you file the examination, you can expect that the first office action is going to be issued by the examiner about 15 to 24 months after requesting examination. And then after that, you have 4 months to respond, and the examiner is probably going to come back within 8 to 12 months, and then you pay the issue fee and things like that. So there are also ways to expedite examination. Like we have Canada is member of the PPH system, so the Patent Prosecution Highway. So that means that if you already got a patent in the US or Europe, for instance, you can request the Canadian examiner to look at similar claims, and based on that positive opinion, we can expedite the process. We also have expedited examination for green technologies. So every invention that relates, I don't know, to biofuel, to clean energy and things like that, you can expedite the prosecution for free. There's no cost for that. And if you don't fit in any of these 2 categories, you can always pay a $500 fee in Canada, and then you expedite examination. And in all cases, when we file for accelerated examination, within 3 to 4 months, we receive a first office action. So it's quite quick.
In Europe, as I said before, from the filing point to the granting of the European patent application usually is between 3 to 5 years process. Of course, as Serge said, it depends on the strategy of the applicant, and it depends on how good is the invention or how is the prior art examiners found. As I said before, it's from 3 to 5 years to get the patent granted, and the cost can be very variable. I can say that on average, what I see is that we get from 2 to 3 examination office sections, which we call them more like examination reports in Europe. So you file the European application, about between 6, 8 months, you get the search and examination. Of course, it depends if we are filing a European application directly claiming the US or Canadian application, or if we are entering the EPO phase through a PCT application. This is a little bit different. And usually you get 1 office action per year, more or less. You can also in Europe accelerate the prosecution by applying to accelerated program, but of course you cannot ask the European examiners to accelerate examination, but you also has to be expedite in replying to the office actions. So the cost can be very variable because you don't know how many office actions to expect, and also there are a lot of costs. Once the European patent gets granted, you have to decide in how many European contracting states you want to validate the European patent. So if there are 2 or 3, will be 1 cost. If you want the 38 or 44, all of them will be an exponential cost compared to only a few states. What I can say and suggest is if you have a Canadian or US patent application, if you want to decide between applying for a European patent application or going directly through 1 or 2 European countries, if you have more than 2, I would say, European countries, then the European route would be much more advantageous. Since you will have 1 examiner, 1 examination procedure in 1 language and 1 outcome. So if you file, for example, in France and the UK, you will have 2 examiners, 2 examinations, two different patent offices, and then the outcome could be different because maybe the prior art which the UK examiner is relying is different to the French examiner, and so on. So if you have from 2 or more than 2 European countries, then the European route is preferable.
Okay, great. Thank you. I think now we should open the presentation to any questions from the audience members at this time. Okay, it looks like there aren't any questions at this time. I just want to take.
I have a question.
Okay, go ahead. I didn't see your hand.
Sure. So if I'm an entrepreneur and with a limited budget, what are some strategies that I could use to obtain protection in Canada and Europe that don't necessarily involve huge amounts of money? I think Canada is pretty reasonably priced, but Europe as well on the patent side. So I'd appreciate hearing comments about that.
For Europe, if the firm is, the size of the firm is not very big, you can ask for filing fees and claim fees reduction. Then, of course, if you have more than 15 claims, you are paying much more at filing. So you can save claim fees and filing fees and so on, but it is a little bit costly, but you end up with a very strong patent which can be nationalized in several European countries.
Is it almost always, if you're going to have a limited country list, is it almost always more economical to go through the European examination as opposed to entering the countries directly?
I would say if you are interested in 2 or more European countries, then I would go for the European patent route application. It would be much more cost effective than going to the national ones. Because you have also the problem of the translations, because with the European route, you need to translate maybe the final European application once you decide to validate. So at the end of the procedure, if you go to, let's say, okay, if you go to the UK, you don't need to translate the application, the US application. But if you go to France, Italy, and Germany, you need to translate in 3 languages the whole application at the very beginning of the procedure. And then maybe at the end of the procedure, you get the patent granted in Germany and the UK and maybe refused in the other country.
Very, very good. And then one other point too is that inventors need to keep in mind that they're paying maintenance fees during the period where the application is pending, right? So that's sometimes we in the US have to remind our inventors that it's the filing fee, and then you have to pay a yearly fee to keep the application pending in many countries, but especially in Europe for sure. But I don't think that's the case in Canada, right?
Yes, you have to pay some maintenance fee, but it's not expensive, at least for the first few years. The fees increase as you go on.
Okay.
Yeah.
If your question includes design patents, this is much easier. So it's cost effective. It's granted very quickly. It doesn't go through novelty examination. You don't have annuity, so you don't pay annually fees. So you get a design patents very, very quickly in Europe, and it's very effective. the cost is reasonable, and as I said, the matter that you can protect is also very broad. So prior to, if you have something that might have some ornamental side, and you want to enforce the products and want to have a unit, a unique and whole big picture for Europe, you should go for design patterns for Europe. European community designs is called, but it's a corresponding match of the US design pattern.
I have more questions if anyone wants to indulge me. So how does, if you're, again, a smaller firm, you're focusing on, growing your business, for us here it would be US clients. Suppose we do file and obtain protection in Canada and Europe. Any suggestions about how we can identify potential infringers under those circumstances if we don't have a staff that is located outside the US?
I would say the easiest way is to set up some kind of Google alert. So you can easily monitor that, because nowadays everyone is on the web, of course. Other than that, there are for sure some firms and companies are dedicated to doing that search. Maybe Jane can comment on trademarks. I believe that there's some kind of police system that can get maybe put in place.
Right, for trademarks, we can monitor the trademark register, and it's like a monitoring system, and it can monitor if there's a new application file that's similar to your mark. And you can also monitor the opposition period. So you have that window if you do want to take actions, like initiate the opposition proceeding, you will be able to do so during that stage.
Great. From a trademark perspective, are there advantages to using Madrid versus entering the countries directly? It seems to me that with the Madrid, right, you can get the earlier filing date for a trademark application, but for entrepreneur, it might make more sense to file the trademark when they're actually starting to do business in that country, or is that not the best strategy?
Well, it depends also on the intention to use the mark and where the company wants to use the mark. Basically, going through Madrid or going directly to the UIPO is a matter of timing. So going through WIPO, takes more time. And since you file the application centrally, you can miss some information or details, so the office action is more likely to occur. But apart from that, the process is very straightforward in both cases, because in both the Hague system for international designs and the WIPO Madrid for trademarks is convenient also for European Union titles, trademarks, and designs.
Okay. Does anybody else have any other comments or questions?
I think Elizabeth does. I see her raising
Elizabeth
her hand.
does.
Yep.
Yeah, I'm just wondering, so sometimes in the US, if somebody's infringing, all it takes is a letter to get them to stop. Sometimes you go all the way through the whole process to court, they appeal the verdict, et cetera, et cetera. I'm just wondering, in your countries, like, how hard is it to actually enforce your marks and your patents?
Well, as Hugo said, we don't have a European enforcement unit. So there is not a court, European court, where you can enforce the European trademark. So the European Union as a trademark as a whole, European trademark, but when you have to enforce it, you have to find the right location where the infringement is occurring, and this is also convenient because you can do some forum shopping, around Europe. based on costs, based on time to decisions. So there are countries that are more, more flexible on some certain matters. There are courts that are specialized, as sometimes we said in Italy, we have IP courts that are specialized courts. So when you go to Milan for fashion or for food, you know that you will have a judge that is specialized only in IP matter. So sometimes when you have infringement elsewhere, and also the matter of online infringement helps us with the forum shopping. So since the infringement is visible everywhere in Europe, so if you buy a product in Madrid, you get the Spanish court, the Spanish courts. If you buy the products in Germany, you do for Germany. So the forum shopping in Europe is more flexible, also because there are no unitary courts for infringement.
So the strategy there, if I can just summarize to make sure I understand, is that you would pick a country whose laws are most favorable to your case.
Exactly.
You would hope that a successful outcome there would then allow you to negotiate some sort of settlement across all of the Europe, all of the EU.
Exactly.
Yeah.
Exactly. And
Good.
especially on the trademark side, the preliminary injunctions are very convenient because if viable, you get very quickly, in 15 days, 20 days, you get a decision. So, and if you have a strong trademark, design, patent, so you get a decision on the, on the search and seizure in very, very few days. And very convenient. It's more convenient than ordinary proceedings that can take much longer.
Great, thank you.
Maybe I can say a few words for Canada. As I say, even though I'm not a litigator, there are maybe some interesting things to know. The law has changed a few years ago, where now for these kind of C's and D's letters, there are some criteria for them to be applicable or valuable in court, because that was in the wake of all the trolls wave. And so now, like, you cannot just send a letter saying, well, you infringe my patents, and then you got a shopping list of patents without any idea what is the products being infringed and what are the patents. And so now there is some kind of requirement that are need to be met, like maybe a claim chart, identify the products and things like that. So it's helpful for any company doing business in Canada. Even though you can do some forum shopping as well in Canada, like in Quebec. For patenting, you have to go to federal court, but in Quebec, you can do that in French. So that can be very convenient as well, because then if the other party is an English company or Anglophone, then it's going to be much more complicated for them to do the proceedings in French. So that's sometimes some kind of trick.
Well, that's tricky.
Have you?
And we've done that many times.
Well, it must.
Have you noticed? Wait, I want to follow up with a question. Have you noticed then that the troll lawsuits have gone down since you passed that new law?
I cannot comment on that. I haven't seen the stats. Sorry.
Okay.
No comment. Well, I like the language angle. Of course, that could work in Europe as well.
Of course. So each court has its own language. So sometimes if you want to have an adverse party struggle with translations and languages, I do the same also with the European system. So if I have an adverse party which selects a different language, and I want them to, let's say on proof of use, I know that there's some German party, and I want them to translate all from German to English. I start the proceeding in English because I don't want them to have, an easy path to the decision. So, well, it's just a way, translations and languages are also, a very good way to strategize and to make others' life more difficult.
I used to understand that legal proceedings were, enforcement proceedings were less expensive in many European countries. I think the UK and then Germany were the most, tend to be the more expensive, but continental Europe is relatively reasonable in terms of attorney's fees. So you can have an enforcement action. You don't have all of the discovery that you might have in the United States. And so really, if you're looking to enforce rights and maybe not spend as much, then perhaps if it's a global product, then Europe could be a good place to enforce it if you're looking for that. So
Correct.
Canada, I don't know how litigation fees compare to US, but I would imagine are they comparable or lower?
Or much lower. I would say you divide by at least 5.
Okay. So that's something to keep in mind, you know.
Yeah, as I said at the beginning, sometimes Canada can be a good jurisdiction to start litigation on a product that's being patented both in Canada and the US, because it's going to be cheaper for litigation and can be a good case as well to see what kind of prior art is going to come out and things like that.
Fascinating. Absolutely fascinating.
Does anyone else have any questions they want to pose to our speakers today? I don't
Well,
see
what's the weather like in Milan? That's what we all want to know.
It is quite warm now.
Too hot.
We are 27 degrees in sunny.
It looks like it's sunny. We see sun coming through your window there.
Yeah, yes.
Oh my gosh. Nobody ever asks about the weather in New Jersey, by the way. I think even if we tell people, they don't care, but it's kind of cloudy today, so.
In New Jersey. Okay.
Well, I just want to take the time to thank our wonderful speakers today. You guys were very knowledgeable. I sure learned a lot about these topics, and I'm sure our audience did as well. And I just wanted to let everyone here know that we will not be hosting an ESS in June, but we will have one on July 28th. And that topic will be reality show tales. So we'll have some inventors and clients talk about their experience from being on QVC and America's Big Deal. So definitely stay tuned for that email. That's going to be a really interesting topic as well.